Toshi, you can start.
The judgment writing competition looks at a broad aspect of how laws learned about in classrooms are actually put to effect and implemented in courtrooms, where facts play a crucial role and law is applied to these facts to set binding legal precedents and pave way for judge-made law. Good afternoon, respected teachers and students. Welcome to the training session for judgment writing competition. This is basically an overview of the entire competition. Before starting the session, I would like to invite Professor Dr. Pallavi Gupta for her warm greeting. Pallavi, ma'am.
Thank you, Toshi, for calling me, for inviting me. With the welcome note of Professor Okay, thank you, Toshi, for inviting me. Dr. Amit Gupta, our chairman, James School of Law, not just James School of Law, James family, campus director, Professor R.K. Raghuvanshi, their HODs, professors, and all the faculty members and students. It's a privilege. We have Professor Dr. Naresh Kumar Bahl, our we can say today the guest speaker of the today's event. Definitely, this judgment writing is a skill which is possessed by the judges only. It's not a skill which every person can have. And this skill is to give the justice or to deliver the justice to the society at large. So it is very much required for a judge to be trained how to write the just to deliver the justice. As you know, when a judge delivers the judgment, he or she keep in mind the arguments of the plaintiff counsel, defendant counsel, and they keep in mind the facts of the case and the issues which are framed. Besides that, judgment keep in mind the existing law. If the case is new, no existing law, in that case, judge has to look into the international convention, the judgment of the other country, the judiciary of other country as well. So this skill is required to be trained, to be given to all the students who want to be part of judiciary. So this is the first step to be known how, to be aware how a judge is writing judgment. So thank you, Professor Well, you have given the consent for this. Wish you good luck, and the students hope you will take this lecture, this training session to be followed by a competition which is going to be conducted by Debate and Discussion Society. Good luck, Debate and Discussion Society organizer. Over to Toshi.
Thank you so much, ma'am. Now, I would like to introduce Dr. N.K. Behel, sir, who is a director and Judicial Training Academy. And he is also a professor of law, and he was a former district and session judge too. So I would like to call him. Over to you, sir.
Thank you, Toshi. Honorable the Chairman, Dr. Amit Gupta ji, Campus Director, Dr. R.K. Raghuvanshi sir, Principal, Gemtech School of Law, Professor Dr. Pallavi Gupta ma'am, Dr. A.K. Tyagi sir, all HODs present over here.
Well, sir, I'm sorry to interrupt. Technical team, find out this Rachit. Who is this? Rachit. Remove him or her from the participation list. And disable the chat box. Disable the chat box. Who is this
Coordinators
Rachit?
of the event: Tanvi Sharma ma'am, Gaurav Saha sir, Vignesh Balaji, Rahul Arora sir, and Priyadarshini Tiwari ma'am. Students coordinators: Bhavna Verma, the convener of the day, Kumar Aditya, co-convener, Dhruv Chaudhary, secretary, and anchor for the day, dear Toshi Khandelwal. I believe that many of our students will become judges in the coming days, and they will be writing judgment while sitting in a court. So today's training session relates to how to write a civil judgment. Dear students, judgment writing requires a taking of decision, and taking decision is a difficult task. Almost daily, my wife used to ask me a question कि ब्रेकफास्ट में आपके लिए क्या बना दो, क्या खाओगे? मैं बोलता हूँ जो मर्जी बना दो. Why? Because in a position to take the decision, I cannot take the decision that what is to be cooked in breakfast today. So decision making is not an easy task. Before we dwell upon the actual drafting and actual process of how to write a judgment, dear students, we must know the distinction between an order, a judgment, and a decree. See, the difference between order and judgment is that judgments are the final outcome of the case given by a judge, whereas orders are passed by a judge, say commanding a specific party to do a specific act. Before or during the trial, a judge may order a witness to appear in the court, or judge may order a party to produce documents, or judge may reject an amendment application or adjournment application. So all these orders are not judgment. They are interim orders passed by the court, whereas the judgment is the final outcome of the case given by a judge. Now, what are the essentials of a judgment when you are going to write a judgment? A judgment contains facts of the case, as Dr. Palvi Gupta ma'am has also elaborated it. Facts of the case, then the issues involved, then evidence brought by the parties, then findings on each and every issue. Of course, the findings are based on evidence and arguments. So every judgment shall include a pressy of the pleadings, pressy of the plaint, pressy of the written statement, and then issues, findings on each and every issue, writing down the ratio decidendi of the cases, and finally the relief granted by the court. Dear students, judgment and grounds of judgment are two different concepts. A judgment or order is the specific decision which can be enforced by the various procedures available within the litigation framework of our legal system. But on the other hand, the grounds of judgment contain the reasons explaining and justifying the decision that has been made by the judge. And judgments play a very important role in the working of our judicial system because they act as precedents for cases to come in the near future. A judge in the judgment pronounced always states the reasons for such decision. And while writing judgment, an important aspect which you must keep in mind is the burden of proof. On whom the burden of proof was there to prove his case. Suppose there are 10 issues in a judgment. The burden of proof of few issues may be on plaintiff, and burden of proving other issues may be on the defendant. So judgment has to be taken, decision has to be taken always keeping in mind on whom the burden of proof lies. And in civil cases, as you know, the burden of proof is on the plaintiff, and it must usually prevail by preponderance of evidences produced before the court. So, dear students, in civil cases, the required standard of proof is also important. Not only burden of proof on whom it is lying, but the standard of proof. Standard of proof in civil and criminal cases is different. In civil cases, it is the balance of probabilities, preponderance of probabilities of the evidence, whereas on criminal side, the standard of burden is beyond reasonable doubt. Unless a case is proved beyond reasonable doubt, you cannot punish an accused person. But on the civil side, the standard of proof is slightly lighter. It's not like beyond reasonable doubt. Plaintiff is not supposed to prove his case beyond reasonable doubt. He has to show that on the basis of evidence, the preponderance of probabilities is that his case is genuine. His case should be believed and it should be decreed. Dear students, here is a chart which distinguishes between judgment and decree, which you must know before you start writing a judgment. See, a judgment is based upon facts and a decree is based upon the judgment. Judgment is made prior to the decree and decree always follows the judgment. The judgment contains the facts of the case, the issues involved, the evidence brought by the parties, and findings on each and every issue, which is based on evidence and arguments. Whereas a decree is the outcome of the judgment, which conclusively determines the rights of the parties with regard to matter in dispute before the court. Then, if you see the definition of judgment as given in CPC, it does not include the word formal, whereas decree is a formal expression of the judgment. Section 2, clause 9 of CPC describes the term judgment, whereas section 2, clause 2 describes the term decree. Judgment is only of one type, whereas decree is divided into three parts. Decree may be preliminary, decree may be final, or thirdly, decree may be partly preliminary and partly final. Whereas judgment is only one, there are no kinds of judgment, and this judgment may result either into a preliminary decree or culminating into a final decree or culminating into partly preliminary and partly final decree. So, dear students, judgment leads to the final disposal of the suit after the decree is drawn up, and it is after passing of the decree that the suit stands disposed of, since the rights of the parties are finally decided when the decree is passed. Then, dear students, you will have to keep in mind that judgment is always pronounced in open court. It is not a secret document. Pronouncement means to make an judgment officially public. Pronouncement of a judgment means that after hearing the parties, when the hearing is completed, after the court has heard the pleadings, arguments, case laws cited by the parties, then judgment shall be announced by the judges in the open court, either at once or at some future date after giving due notice to the parties or their learned counsels. Dear students, I may tell you, it happened so many times when I was working as judicial officer, working as district and sessions judge, that I pronounced the judgment in the open court, say around 4:30 or 5 o'clock. At that time, no one was present in the court except the staff. Even parties were also not present in the court, but legally, we are bound to pronounce judgment even if nobody is hearing it. None of the party is present in the courtroom, only our staff is present, but we have pronounced the judgment like this, that suit of the plaintiff is dismissed. One line pronouncement, and then we retire to our chamber. But this pronouncement is compulsory part of the judgment. And normally this judgment is pronounced within 30 days from the conclusion of the arguments by the parties. Dear students, sometimes it happens that judgment is written by me and I am immediately transferred to another court or I am transferred to another district. Then in such circumstances, Order 20 Rule 2 of CPC provides that a judge with right to pronounce judgment, which is already written by him, but not pronounced by him, it may be pronounced by his successor in office. Whosoever is coming next to me, he will pronounce that judgment. And it is quite possible that one judge may sign the judgment and other may pronounce it if the former is transferred to any other court in the same district or in any other district. Now, dear students, so far as the content of the judgment is concerned, according to Order 20 Rule 4 of CPC, the judgment of a small causes court, this is a different court created under Small Causes Courts Act 1887. This judgment of small causes court are satisfactory if they contain points for determination and decision thereupon. This is a short kind of judgment written by the small causes court because the matter is very petty. But on the other hand, the judgment of civil court shall contain summary of the pleadings, which is a concise statement of the case, then issues known as points for determination, then findings on each and every issue and decision thereon, and then that judgment also contains the reasons for such decision. What is the ratio decidendi of a particular case, and the remedy or the relief granted by the court is also part of the judgment. Now, what is decree? We have understood what is order. We have understood what is a judgment. Now, what is a decree? The term decree is defined in section 2, clause 2. This decree always follows the judgment and is always based upon the judgment. And it is divided into 3 types, as I told you earlier. Final decree, preliminary decree, or partly preliminary and partly final decree. What is the content of the decree? Like you have noticed the contents of the judgment are slightly different from content of the decree. This is the decree shall agree with the judgment. There has to be a perfect harmony between judgment and decree. The decree shall contain the following items. Number 1, suit number and year of the suit. Then name and description of the parties with their registered address. Then particulars of the claim which relief was asked in the plaint. Then what relief was granted by the court. Then amount of the cost incurred in the suit and by whom or out of what property or in what proportion such cost is to be paid. Then date of judgment will come in the decree. Date of decree is also part of the decree according to Order 7, Order 20, Rule 7. And then decree, as I told you, may be signed by successor of the judge if the original judge has been transferred. So dear students, the decree contains the outcome of the suit and it conclusively determines the rights of the parties with regard to issues in dispute in the suit. After passing the decree, the suit stands disposed of since the rights of the parties are finally determined by the court. Then there is another concept of deemed decree also. It's not a perfect decree, but deemed decree. You must have heard the name of a deemed university also. A university which is not a full-fledged university. This is something less than a full-fledged university, as known as deemed university. So we have a deemed degree defined also. A decree shall be deemed to include a rejection of a plaint. If your plaint has been rejected by the court, a decree shall be drawn. And any question within section 144 of CPC relating to restitution. But it shall not include any adjudication from which an appeal lies as an appeal from an order. Suppose your plaint is returned by the court under Order 7. Returning of the plaint is an adjudication, but this order is appealable. Hence, it is not decree. It is not final judgment of the court. And it does not include order of dismissal in default. If your suit has been dismissed in default in the absence of the plaintiff, then definitely order has been passed by the court that suit of plaintiff is dismissed, but it is not a decree. Dear students, what is the necessity of a decree? The necessity is that CPC requires the passing of a decree in all the suits. A decree is based upon the judgment, and I told you that it also follows the judgment, which is the reason why it is indispensable and essential to pass a decree also. And decree is also essential because you can file an appeal against decree only. It is not the judgment against you are filing appeal. So for filing appeal, the decree must be drawn by the court concerned. Dear students, here is the picture of a decree in original suit. You see, judgment may be 800 pages long judgment. You must have read the case of Keshwanand Bharti running into approximately 800 pages. But decree is only a 3-page document. This is the first page where the name of the court, name of the parties, and what was claimed by the plaintiff is mentioned on page number 1. Page number 2, you will see what is granted by the court. The name of the advocates is also mentioned in the decree. As you can see, ABC advocate for plaintiff, XYZ for defendant. And this is the final order given by the court. Final order I would like to read before you. The suit of plaintiff for specific performance of the contract dated 1/1/2017 is decreed with cost against the defendant. Defendant is directed to execute the sale deed of flat in question in favor of plaintiff. The defendant is at liberty to withdraw a sum of rupees 90 lakhs deposited in court by the plaintiff. This is the relief granted by the court, which is mentioned in the decree. Then cost of the suit 15 lakh 1200 503 to be at the along with 6% interest is to be paid by the defendant to the plaintiff. And this is the third page of the decree, which deciphers the cost incurred by each party. You see, on the left hand side, the cost of plaintiff is added, which amounts to 15 lakh 12,503 rupees, and cost incurred by defendant is on the right side, 8,765 rupees. So the decree is only 3-page document. It is based on judgment. Now, dear students, as I told you, the length of the judgment and decree. Judgment can be as lengthy as the requirement of the case may be, but decree is only 3-page long document. I gave you the illustration of Keshwanand Bharti's case, which was running approximately in 800 pages. But if you draw a decree, it will be only 3 pages. Dear students, now you are going to draft a judgment, write a judgment. I have given you certain provisions regarding writing of the judgment. But before you start writing a judgment, you must have the knowledge of hierarchy of civil courts in our country. If I take the example of UP, here is the chart of hierarchy of courts, that on the top of it, Supreme Court of India is there. It has original, appellate and writ jurisdiction. It has SLP jurisdiction also. Then High Court in each state. They also do have appellate, revisional and writ jurisdiction. District judge and additional district judges, they are appellate courts. They can hear appeals up to 25 lakh valuation, starting from 5 lakhs. Revision up to 5 lakh valuation and appeals up to 25 lakh. Then civil judge senior division, parent court, having 3 years experience, they have unlimited original jurisdiction above 5 lakhs. Whereas civil judge junior division can hear cases only up to 5 lakh valuation. So you must have the knowledge of the hierarchy of courts, because you are going to write a judgment. And judgment may be of Supreme Court, judgment may be of High Court, judgment may be of district judge or other subordinate courts. So you should have the knowledge of hierarchy of courts also. And you must be clear in your mind that you are going to write judgment, but about which court? Are you writing a judgment of civil judge junior division or senior division? Even if you are writing a judgment of junior division, civil judge senior division, are you writing a judgment as judge of the small causes under Provincial Small Causes Courts Act 1887? Or you are writing the judgment as prescribed authority under Rent Control Act? Or are you writing a judgment as a district judge? District judge has original jurisdiction, he has appellate jurisdiction also, and he has revisional jurisdiction also. You will have to select in your mind which judgment are you going to write. Then judgment may be of the High Court. High Court also has certain amount of original jurisdiction. They do have appellate jurisdiction. They have revisional jurisdiction and writ jurisdiction also. So which judgment you are going to write, please be clear in your mind. Then you may write the judgment as a Supreme Court judge also. Supreme Court judge also, they do have original jurisdiction, appellate, writ, and specially petition jurisdiction also. You must be clear in your mind. Are you a judge of the House of Lords? Are you a judge of the Privy Council? When you are writing a judgment, then you must be clear, dear students. Are you writing the judgment as part of division bench where two judges are sitting together? Or are you writing a judgment of full bench? Judgment has to be written in full. Some of the judges are agreeing with the written judgments of their co-brothers. They write only one sentence, I agree. You are supposed to draft a complete judgment here. You have no right to say, I agree with my brother judge. And you must be clear in your mind which court you are sitting. If you are writing a judgment of constitutional bench, again the pattern and pro forma may be different. Anyway, dear students, now consolidating the parts of a judgment before you. And I'm talking about a civil judgment only. The first and foremost part of the judgment is name of the court. Suppose you are writing the judgment as civil judge junior division. So you will write down in the opening line will be in the court of civil judge junior division, Gautam Buddha Nagar, UP. Then next line you will write the name of the judge who decides the case. Bracket में आप लिखेंगे present Shri N.K. Behel, bracket close, because I am the presiding officer writing the judgment. Then you will write down the suit number and year. From where you will borrow this suit number and year? From the file of the court. You are dictating your judgment to your stenographer. Then you will write down name, parentage, age, and full address of the plaintiff. Or if there are more than one plaintiff, you will write down name, parentage, age, and full address of all the plaintiffs as mentioned in the plaint. You are not supposed to change the name of the parties or address of the parties. You have no liberty to change it. You will write down name, parentage as is written in the plaint. And versus against whom this case was filed, again you will copy paste it from original plaint. Name, parentage, age, and full address of the defendants is also likewise to be copied from the plaint, and it is to be mentioned in the judgment. So as a presiding officer of the court, as a judge or as a magistrate, you have no right to change the name parties. They have to be taken as it is, even if they have changed their address later on, but in the judgment, you will copy it from the original plaint. Then center heading judgment. After judgment, center heading, the judgment will start in short paragraphs 1, 2, 3, 4 consecutively to be written by you. First of all, you will write down the Pressy of the plaint in short. In the last batch, one of the students in Judicial Training Academy asked me, sir, what is the role of Pressy writing in competitive examination? Here comes the role of Pressy writing. That in judgment, you will precisely write down all the facts mentioned in the plaint. This is the first top part of the judgment. Then after writing the Pressy of the plaint, you will write down Pressy of the written statement. What was the case of the defendant in short? Then next para will be, what were the issues framed by the court? You are not supposed to frame issues at the time of writing judgment because the issues have already been framed long time back. So you will take the issues from the previous order sheet of the file. Then, dear students, you will have to summarize and write down the oral and documentary evidence produced by the plaintiff first, and then oral and documentary evidence produced by the defendant. Then you are supposed to give findings on each and every issue one by one. Unless two or more issues can be clubbed together, if they relate to common matter and evidence on them is also common, then you can take up more than one issue at a time also. But the normal thumb rule is that finding is to be given on each and every issue one by one. For example, we start with issue number 1. So, issue number 1, we will discuss the evidence of the plaintiff first. What plaintiff has said with reference to issue number 1. And suppose plaintiff has produced 4 witnesses. So you will write down that in support of issue number 1, prosecution witness number 1, that is PW1, stated that what he has stated in his statement, which has already been recorded long back, you will summarize what the plaintiff as prosecution witness number 1 has stated in his examination in chief. Then you are to refer his cross-examination also, because the value of the evidence is to be weighed keeping in mind the contradictions or support between examination in chief and cross-examination. Likewise, with reference to issue number 1, you will write down the other witnesses also. PW2 stated, prosecution witness number 2 stated that whatever he has said, you will precise it in your judgment. And then what he said in his cross-examination also, you will mention. Likewise, what PW3 stated, what PW4 stated, you will have to briefly write down their statements on oath given in the court. And you will write down the cross-examination of each and every witness to weigh the evidence. Then, dear students, there is another area which is part of the judgment. You will have to write down the demeanor of the witness if it was noted on record by the judge when his statement was recorded. Demeanor means the impression of the judge regarding witness. हिंदी में बोले तो गवाह का क्या हाव भाव था, whether he was confident while giving evidence or he was ill confident, he was telling a lie, he was sweating a lot, पसीने आ रहे थे उसको बयान देते वक्त, because he was telling a lie. So this demeanor of witness is recorded at the time of recording of the evidence of the witness. So you will have to copy the demeanor of the witness in order to arrive at a particular conclusion if you are believing or not believing the statement of a particular witness. Order 18 Rule 12 of CPC requires that a judge is at liberty to note down the demeanor of the witness. And on criminal side also, section 280 CRPC is there, where the judge has a right to note down the demeanor of the witness. Because demeanor, unless noted, you cannot remember it till the date of judgment. And maybe that judge has been transferred, so his successor will read out the demeanor written by his predecessor. And then, dear students, another important part of the judgment is write down whether document was proved by the witness or not by marking of exhibits at the time of recording of evidence. If I have filed a suit for specific performance of the contract based on original agreement, then original agreement has to be proved by some witness by marking of exhibit at the time of recording of evidence. I'll illustrate it further. Then once you have mentioned the entire evidence of the plaintiff on issue number 1, then you are supposed to discuss the evidence produced by the defendant in support of issue number 1. What he says, he has also produced 4 witnesses. Defense witness number 1, DW1, DW2, 3 and 4. So with reference to issue number 1, because you are taking up the issues one by one, you will have to write down what defendant number 1 has stated in his examination in chief and what he has stated in his cross-examination. So examination in chief plus cross-examination is to be mentioned in the judgment, and from where you will take it, because the statement has already been recorded and it is on the file, you will have to copy it from the statement already recorded. Likewise, you will note down the demeanor of defense witnesses or defendant's witnesses also. Like you noted the demeanor of plaintiff's witnesses, you will write down in your judgment the demeanor of the defense witnesses, which was recorded by you or your predecessor at the time of recording of the statement. Now, dear students, with reference to each issue, you will have to write down which document was proved by which defense witness by marking of exhibits at the time of recording of their evidence. So this is an illustration of issue number 1 only, that how much oral evidence was produced by the plaintiff, how much documentary evidence was produced by the plaintiff, and then how much oral evidence and documentary evidence was produced by defendant. You will come to a conclusion whether the agreement was a genuine agreement between the parties for sale deed or not. Likewise, you will decide all issues one by one. This is the requirement of Order 20, Rule 5 of CPC. Before deciding or before coming to any conclusion, you will mention the arguments put forward by each counsel. What was said by the plaintiff's counsel? What was argued by the counsel for defendant? You will have to mention in the judgment. And then you will have to mention the case law cited by each party, and you will discuss whether their ratio decidendi, reason for the decision, is applicable to the facts of the case before you or not. And I told you in the beginning that in the judgment you will write down on whom the burden of proof lies. Write down judgment according to burden of proof. Whether plaintiff is able to prove his case or not is a different issue. I told you that if there are 10 issues, plaintiff has the burden of proving few issues and defendant has the burden of proving few issues. So unless you stress upon on whom the burden of proof lies, you cannot write a good judgment. Your judgment is likely to be dwindled here and there unless you know on whom the burden of proof lies. Now, coming back to marking of exhibit, how it is done, although it has already been done before writing judgment, but I am illustrating you what is the meaning of marking of exhibits. Exhibit means to publicly display. If I had an agreement with builder for sale deed, I must display that agreement before the court. I must prove my signatures. I must prove the signature of the builder on that agreement. So exhibit means to publicly display the document. Exhibit does not mean that the case has been fully proved. Even if I have exhibited my agreement to sell, it does not mean that my case will be decreed. It is one piece of evidence which the court will weigh. Exhibit marking means that it has been shown as it exists or was existing at the time of its execution. The word exhibit has been taken from exhibition. You go to Pragati Maidans so many times and you see so many like books exhibition, garments exhibition. What is the meaning of exhibition? That everything is displayed there publicly. Aapko jo cheez pasand aaye kharid lijiye. Here also, marking of exhibit means that you are publicly displaying that document before the judge. He has to take the decision. The court may or may not attach full value to an exhibit in the light of other evidences on the file. Fine that I have exhibited my agreement to sell before the court. That does not mean that my case shall be decreed, because court may or may not believe the value of the document in the light of other evidences. And dear students, on behalf of plaintiff, the documents produced by the plaintiff when proved in the court by oral statement are marked as exhibit A1, A2, A3, so on and so forth. And for defendant, they are marked as exhibit B1, B2, B3, so on and so forth, if the documents are produced and proved by the defendant. Dear students, here is an example before you how to exhibit a document. See, this is the envelope with the, I sent a notice to my builder. I'm sending this notice to his advocate that you are not executing sale deed in my favor. This is the envelope. I sent this notice by registered AD post. The name of the person, name of the advocate is Mr. Javed Akhtar Advocate. I have sent this notice to him because he is counsel for the builder. Sender's name is mentioned on the left hand side. You can see Dr. N.K. Behel and complete address is there. 25 rupees stamp, postal stamp is also fixed on it. So this envelope was sent to other party. Notice printout of the notice was kept in this envelope. This is the receipt issued by the post office to me when I sent this notice to the counsel for builder. This is the acknowledgement card which I received back when Mr. Javed Akhtar Advocate received my notice. This AD card is marked as Exhibit 1 during recording of statement of the witness. And this exhibit word is to be written in red ink according to the High Court rules. Marking of exhibit is to be done in red ink. And see the back side of this card also. I sent this notice. So this AD card will come back to me. And it has come back to my address. My name, Dr. N.K. Behel, and complete residential address was mentioned on this AD card. So this is a method. How do you mark exhibit on a document? And please note that this marking of exhibit has been done prior to the recording of the, prior to the dictation of the judgment. So you have written the findings on each and every issue. Then finally, you will write down net and final conclusion of the court. What is the conclusion of the court? Whether the suit is liable to be dismissed or whether the suit is liable to be decreed or not. Then after that final conclusion, again a center heading order will come. And in that order, you will write down the final conclusion of the court. For example, you will write down the suit of the plaintiff is dismissed. Thereafter, signature of the presiding officer are required. The presiding officer will put his signatures with complete designation. Why designation is important? Again, whether you have written this judgment as Judge Small Causes Court or whether you have written this judgment as Civil Judge Junior Division or Senior Division or District Judge or High Court or a Judge of the Supreme Court. So you are supposed to write down complete designation of the judge also. Then date of signing of the judgment is also part of the judgment. Now comes the pronouncement of the judgment. Judgment has to be pronounced in open court. And after pronouncement, again the signatures of presiding officer or judge of the court are required with complete designation. So dear students, please note that this judgment is to be signed twice. One on the conclusion of the judgment and then after pronouncement also. And then you will write down the date of pronouncement of the judgment also. And once you have signed the judgment, once you have pronounced the judgment, my dear students, the doctrine of functus officio applies. Your function as a judge is over. No alteration in the judgment is allowed once you have signed the judgment. You are not at liberty to change the judgment. The judgment may be challenged in appeal is a different issue. You may change your judgment in review also. That is also a different thing. But you cannot change the original judgment. You have no right to touch the original judgment once you have pronounced it and signed it. Except for clerical errors as provided in section 152 of CRPC, you can rectify the clerical mistakes, but not the judgment itself. So dear students, this was all about the ingredients of judgment. Now let us see a sample of a written judgment. It is written by one of my students and a good judgment for your perusal. It contains all those ingredients or not. We'll just quickly see. See, first of all, the name of the court is there. In the Court of Civil Judge Junior Division, Gautam Buddha Nagar, UP. Yes, this was our first ingredient. Then present Shri ABC, name of the judge. Then name, parentage, complete residential address of plaintiff number 1. Then plaintiff number 2 versus our defendant is K son of Q. the resident of 910 Designers Park, Sector 62, Noida. Center heading Judgement. So this sample contains all the ingredients or not, we have to see. See the judgment. Para number 1. Plaintiffs have filed the present suit for damages for rupees 30,000 on account of their malicious prosecution in a criminal case. This case is illustrated. It contains a civil suit for claim of damages of 30,000 rupees because of malicious prosecution. This civil judgment has two dimensions. One is a criminal judgment at the back of it. Suppose I was wrongly prosecuted by someone and court acquitted me. I was maliciously prosecuted by my opponent party. Now, since I have been acquitted by the court, I am claiming damages because of my defamation, because of my malicious prosecution. Now, para 2, 3, 4 is giving the background facts as to how I was prosecuted in a criminal case. So, para number 2, 3, 4, 5, all are relating to the Pressy of the plaint which plaintiff has filed in the court. And you are explaining in these paragraphs as to how you were
Excuse me, sir.
acquitted by the criminal
Excuse me,
court.
sir. Sir,
Yeah.
sorry to interrupt, but you are not, the sample is not visible.
Pardon?
Sorry to interrupt, but the sample is not visible.
Okay, I'll check. Is it visible now?
Yes, sir, now it is visible.
It is visible now?
Yes, sir, yes, sir.
Okay. So dear students, this is a sample of written judgment written by one of my students. And with the help of this illustration, we'll check whether all ingredients of judgment are there or not. See, on the top of it, the name of the court is there. That is in the Court of Civil Judge Junior Division, Gautam Buddha Nagar, UP. Name of the court, first ingredient. Second, name of the presiding officer, Present Shri ABC. Then complete name and parentage and address of the plaintiff, and then complete name, parentage and address of the defendant. In this illustration, we have two plaintiffs, plaintiff number 1, plaintiff number 2, versus K son of Q is our defendant. Then comes another ingredient, that is center heading judgment. After center heading, you will write down the brief facts which are mentioned in the plaint. Pressy of the plaint you are supposed to write. So para 1 says, plaintiff has filed this suit for damages for rupees 30,000 on account of their malicious prosecution in a criminal case. I am one of the plaintiff. Myself and my brother, two persons were prosecuted by our opponent in a criminal case. And finally, we were acquitted. Court found that we are not involved in the criminal case. Now the plaintiffs are now filing a suit for damages against that complainant who had lodged FIR at the police station because he had prosecuted us with malicious intention. उन्होंने कहा कि बहल साहब को बदनाम कर दो, झूठा केस लगा दो, लगा दिया. अब कोर्ट में दूध का दूध, पानी का पानी. I was acquitted. Now I am filing this civil suit for damages against that fellow who had lodged a false FIR against me with a malicious intention. And para 2, the facts giving rise to this suit according to the plaint are that they were prosecuted by the defendant in a false case. Subsequent paragraphs are giving the details of that criminal case in which the plaintiffs are acquitted. They were prosecuted for murder. And finally, they were acquitted by the competent court. So, para number 1, 2, 3, 4, 5, 6, they are with reference to the previous criminal proceedings. They are mentioned in the plaint. Up to para 7, this is the summary of the plaint. From para 8, the summary of written statement starts. See, para 8. The case of the defendant in his written statement was that the defendant has denied all the allegations of the plaintiff. Whatever is said in the WS, you are supposed to make down Pressy of it. Para 8, 9, 10, 11. They relate to the summary of the written statement given by the present defendant. Then comes framing of issues. Let us see. Following issues were framed by the court. Issue number 1, whether the plaintiff was prosecuted by the defendant, you will have to give finding on it. Issue number 2, whether the proceedings terminated in favor of the plaintiff, if from their nature they were capable of so terminating. So 1 to 10, there are 10 issues, and the 10th issue is whether plaintiff is entitled to any relief. If yes, what? These 10 issues are part of the judgment. They have already been framed. आप कहाँ से लेंगे इसको? From the file of the court. Then you will have to give the summary of evidence produced by both the parties. Para 13, oral evidence produced by the plaintiff is as follows. 4 तो गवाह दिए इन्होंने, witness number 1, 2, 3 and 4. And para 14, plaintiff has filed following documentary evidence. Certified copy of the judgment of criminal court in which plaintiffs were acquitted, marked as Exhibit A1. This was document filed by the plaintiff. Then you are giving findings on issue number 1, 3 and 4. First of all, you will write down with reference to these 3 issues what was said by prosecution witness number 1 in his examination in chief. Uski brief summary aayegi. Thereafter, what was said by, in his examination in chief, he proved the judgment of previous criminal court as Exhibit A1. Then in his cross-examination, what he deposed, because you will have to weigh the value of the statement of a witness in the light of his examination in chief vis-a-vis his cross-examination. Then you will write down what was said by second witness with reference to these 3 issues. Second witness ने क्या बयान दिया, वो आपको summary लिखनी होगी. Then its cross-examination also. In his cross-examination, what witness number 2 stated, you will have to write down. Then what was said by PW3, third witness. Then what was said by fourth witness of the plaintiff. Then with the reference to same issues, what is the evidence of defendant? Para 19 देखिए. Evidences filed by the defendant are as follows. Only defendant was produced as defense witness number 1 and no documentary evidence was filed by the defendant. Now you have to take into account what was said by DW1. Defendant is the only person who deposed himself as defense witness, defendant's witness. तो उसने अपने examination in chief में क्या कहा? You will have to summarize it briefly. Then what he said is in his cross examination. You will have to summarize it. Then this leading case was produced before you. Para number 21, last part. The leading case of Balbhadra Singh and another versus Badri Shah and another, AIR 1926, Privy Council, page 46 was cited in support of the arguments of the plaintiff. Now you are supposed to read and write down what was the ratio decidendi of this case. Para 22 contains the ratio decidendi of this case, which has been cited before you by the plaintiff in support of his case. So para 22 contains what was held in that case. A, B, C, D, E. These 5 ingredients are to be proved if the case of malicious prosecution is to be decreed. Then you will write down your discussion. What was said by plaintiff's evidence, plaintiff's statement, their documentary evidence, what was said by the defendant, what documentary evidence is produced. Then you will write down burden of proof on whom it was. One of the paragraph before you is the burden of proving issue number 1, 3 and 4 was on the plaintiff. But in my considered opinion, the plaintiff has failed to prove that plaintiff was prosecuted by the defendant. He also failed to prove that prosecution was instituted against the plaintiffs without any reasonable and probable cause. And plaintiff also failed to prove that prosecution was launched with a malicious intention of the defendant. You will have to give a categorical finding after keeping in mind the burden of proof. Then at the time of arrival of your conclusion, you will write down the demeanor of witnesses. Demeanor of witness number 1 and 2 was recorded by the judge at the time of recording of evidence. Then you will give findings on next issues. Issue number 1, 3 and 5 you have 1, 3 and 4 you have decided. Now findings of the court on issue number 2 and 5. You will take up the issues one by one. Again, in support of these issues, what was said by the plaintiff, what was said by the defendant and their witnesses will have to be written by you. And then you can come at the conclusion regarding the decision on a particular issue. Then see para 25. Findings on issue number 6, 7, 8 and 9. Issue number 6 relating to cause of action, 7 relating to jurisdiction, 8 relating to valuation and paid court fee, and 9th relating to suit being barred by limitation were already decided by my predecessor as preliminary issues and will remain part of this judgment. These issues have already been decided because the defendant, if defendant has raised this issue that plaintiff has no cause of action, then this has to be decided as preliminary issue. Defendant has raised the issue that court has no jurisdiction to decide this case, then this issue has to be decided first. If defendant says paid court fees is less, valuation is less, it has to be decided in advance. And if the defendant says that suit of the plaintiff is barred by limitation, again this issue has to be decided first before other issues. So these issues have already been decided and they will become part of the judgment. Now para 26 is the most important part, which speaks about the mind of the judge, what he has arrived at. See para 26. I have given careful thought to the submissions of learned counsels from both the sides. I have also gone through the record file. I have also studied the case law cited at the bar. It was argued at the bar that K never instituted. Now you can write down what was argued by the plaintiff's counsel, what was argued by the defendant counsel. Then your finding. I am of the opinion. This is your finding. This is the mind of the judge. And finally, you can conclude that plaintiff failed to prove that he was wrongly prosecuted or he was maliciously prosecuted by the complainant. And see para 27, very important. The facts of the present case are very much similar to the facts of Balbhadar Singh and another versus Badri Shah and another, published judgment in AIR 1926, Privy Council, page 46, decided by the Privy Council, and the ratio decidendi of the case law cited on behalf of the defendant is squarely applicable to the facts of the present case. In this leading case, the suit of malicious prosecution was dismissed by the Privy Council because all the 5 ingredients of malicious prosecution were not proved. And in this case also, the plaintiff could not prove the 5 ingredients of malicious prosecution. Hence, finding on issue number 10 is para 20. In my opinion, the plaintiff have failed to prove all the requirements of a malicious prosecution as held in Balbhadar Singh and another versus Badri Shah and another, decided by the Privy Council. The plaintiffs are not entitled to any relief. The present suit for the damages on account of malicious prosecution is liable to be dismissed. Abhi aap keh rahe hain liable to be dismissed. Para 29, in view of findings on issues number 1 to 10, the suit of plaintiff for damages on account of malicious prosecution is liable to be dismissed, parties to bear their own costs. Now center heading order. Final order is the suit of plaintiff for damages on account of malicious prosecution is dismissed, parties will bear their own costs. Date of the judgment is 25th May 2021, signature of ABC judge. On the top of the judgment, you had written the name of the judge, present Shri ABC. So ABC will sign this judgment with complete designation, Civil Judge Junior Division, Gautam Buddha Nagar, UP, you are supposed to draft. Then this judgment signed, dated and pronounced in open court. Judgment will be signed first, then date will be mentioned, and then it will be pronounced in open court. Pronouncement will be only of this operative part. Judge will not read out whole of the judgment, 800 pages. Order is to be read out in the open court. The suit of the plaintiff for damages on account of malicious prosecution is dismissed. Parties will bear their own cost. This is the pronouncement of the judgment, and date of pronouncement is the same, 25th May 2021. Again, judge will sign it. Signed by ABC Judge, Civil Judge Junior Division, District, Gautam Buddha Nagar, UP. So my dear students, I hope that I have been able to explain you what is an order, what is a judgment, what is a decree, what is the distinction between judgment and decree. Then I explained you what are the ingredients of a judgment, how many steps are required for writing a judgment. I hope it will benefit you in your career. I wish you all the best. Many of you will become judges in various states, and I wish that all the best to you. You may become judge of the High Court and take the flag of GemTech once again flying in your hands. So thank you very much. All the best to you. God bless all of you. Thank you again. Over to you, Toshi. If you have any questions, you are welcome.
Thank you, sir, for explaining it very well, but I'll still give students a summary about it. So, sir told us, first of all, sir told us how judgment making is a very difficult task. He also told us difference between judgment, order, and decree, and most importantly, their necessity. He also told us how to write a judgment and what are the most important things while writing a judgment, such as facts and arguments, pressy of the pleadings, finding issues, burden and standard of proof, knowledge and hierarchy of civil code. Judgment writing is not that easy that it's over at once. It is very important that is as it is used as a precedent after that too. So also told us judgment should always be in open court as it is an official public announcement. While telling us that, he also told us how much description and demeanor of the party also is an important thing. So now we would take questions from people, from everyone. I just ask, I'll just see.
You are welcome to ask any question.
So some of the students are asking to please differentiate between preliminary decree and partially preliminary.
Please repeat your question. Please, I was not able to take it up.
So students are asking to differentiate between preliminary decree and partially preliminary decree.
Yeah, you see, especially in partition suits, initially, suppose you have claimed 1/4 share in the property. So initial judgment will be pronounced by the court whether you have 1/4 share in the disputed property or not. After this judgment, preliminary decree will be prepared. But which 1/4 share you are likely to get? Everybody wants कि मुझे road side वाला share मिल जाए, back side का share ना मिले. So you want 1/4 share by meets and bounds. So another decree will be pronounced later on. Initial decree may be partly preliminary and partly final, but final decree has to be prepared after meets and bounds about the area which you will get in your 1/4 share. Initial decree had given you the answer that your share is 1/4 fine, but which side is to be decided later on by the court, and that is known as final decree. First decree will be partly preliminary and partly final.
So the next question is, what is demeanor and how is it relevant to judgment?
Please repeat your question.
So what is demeanor and how it is relevant to judgment?
Yeah, demeanor of the witness, I told you its meaning in Hindi also. कि गवाह का हाव भाव क्या है? What is his body language? Was he telling truths or was he sweating because of he was telling a lie? So judge by putting 2-3 questions to a witness can come to conclusion whether the witness is telling a truth or not, or whether he is telling a lie. So demeanor means impression of the witness at the mind of the judge, the body language of the witness, which is noted by the judge at the time of recording of the evidence. It's not at the time of writing of judgment. It has already been done long back, when the statement of the witness was recorded, and witness impression, witness body language, witness personality, and his entire impression has to be noted by the judge. That is known as demeanor of the witness. If demeanor is bad, then value of the statement goes down. If demeanor is on positive side, then the value of his statement increases. That is the value of demeanor of the witness, and it helps the court in arriving the truth.
Thank you,
Yes.
sir. Next question is whether it is necessary to pronounce whole judgment by the judges in the court or just the ratio of the judgment.
See, pronouncement of the judgment is compulsory. The reason is that unless you pronounce the judgment, how parties will come to know it? And there are chances of misuse also. If you do not pronounce the judgment, it is kept in the file. Then somebody say that he says, I have won the case. Another says, I have won the case. You pronounce the judgment in the open court. The reason is that all public comes to know what happened between A and B. What was the result of the suit? The staff of the court should know, entire public should know, the parties should know. That's why pronouncement is compulsory part of the judgment. Yeah.
Okay. So some of the students are asking that can we get the sample and PPT of this?
Yeah, no problem. I can share all these PPTs with students. No problem. I will share.
Thank you so much, sir. Any more questions?
Any other question, please?
So there are no questions, sir. Thank you so much for your time and for explaining us this vast topic. And now I would like to call Ms. Tanvi, ma'am, for a vote of thanks.
Very good afternoon to everybody. A very good afternoon to William, sir. On behalf of the whole GYMS family, I hereby propose a vote of thanks. Although we are, apart from thanks, we're very grateful to hear from you. And apart from the faculty, apart from GYMS faculty fraternity, even the students are also thankful to learn the art of judgment writing from the expert person itself. We have a gem in our GYMS society. And thank you so much, Dev, sir.
Thank you, everyone.
We
Thank
are
you.
very privileged to have you. Thank you so much. Palvi ma'am, would you like to say some words? Okay, thank you so much. And we have our judgment writing competition on 25th of September. The problem regarding judgment writing will be released very soon. And I want all the students from our college to participate in this particular competition. And this could be one step for you to be more closer towards your ultimate goal of becoming a judge. Okay, the competition is on 25th of September. By 25th, you will have to submit your entries for the competition. You have to submit a proper judgment written by you. Okay, thank you so much, everybody. And now I want one of the, yes, sir. You wanted to say anything, sir?
Tanvi, you are not audible.
Okay. Am I audible now?
Your voice is, maybe strong.
Ma'am,
Please speak loud.
Okay. Okay. I want all the faculty coordinators to switch on their cameras. The last thing is we want to click a picture together as a memento, so that we can remember that we conducted an event like this. And I want one of the student committee team member to click a picture of all of us, including all the team members, debate and discussion team members. Please switch on your cameras, and one of you please click a picture.
Tanvi, I would like to say, when the event started, that time 300 students were there. I think more than 300, but at present there is only 130. You just check this thing, means if this effort is taken by Professor Wahel, all should be benefited. So this debate and discussion society must ensure all the participants should remain at the last of the event. Okay.
Bhavya Verma, is it possible for you to click on your camera and click a picture for all of us, team members, please? Everybody, Bhavya and Aditya.
Yes, sure, ma'am. Everybody, please switch on your camera.
Bhavya, is it done?
Yes, ma'am.
Okay.
Vignesh, sir, also could you please switch on your camera? Yes. Okay, I'm taking a screenshot now.
It will be by geotagging. Then we must ensure.
It's done now. Thank you, everybody.
Thank you so much, everybody. Okay.
Thank you all the faculty in charges and our respectable HOD ma'am for the constant